This PowerPoint will explain the City of Toronto's new bylaw that comes into effect on July 31st, 2025 regarding evictions for renovation in residential properties. This is not legal advice. I'm a paralegal, but I'm not your paralegal. So I encourage you to recognize that this is for educational purposes and to seek legal advice if you need it. At the Landlord-Tenant Board, under the Residential Tenancies Act, there's two broad types of applications. Applications to evict where it's the tenant's fault. They've done something wrong, and those are on the left side of the screen. And applications to evict where the tenant's done nothing wrong, yet the landlord requires vacant possession. And this bylaw deals with the N13 notice, which asks the tenant to move out, suggesting that the landlord needs the unit vacant to do extensive renovations. If the tenant moves out and advises the landlord that they wish to return when the work is done, they have the absolute right to do that, to return at the same rent when the work is done. And of course, they would not be required to pay rent during the period that they're out of the unit. Because the tenant's done nothing wrong, the rules are a bit different, and you can't serve the N13 during lease term, only once it's become month to month. And there's a longer termination period of 120 days, and compensation is also required. The problem is that some landlords are using these false renovation claims, saying I have to put in a new countertop, so you have to move out, or I have to put in a new toilet and a sink, so you have to move out. And the landlord's goal is to hope the tenant moves out and doesn't return at the same rent so that they can re-rent it at hopefully a higher rent, or their intention is to intentionally not advise the tenant when the unit is ready and rent it out to somebody else. The Landlord-Tenant Board is very suspicious of these types of N13s because unscrupulous landlords do use this notice to try to get the tenant to move out, having no intention of allowing them to move back in. And of course, the tenant can file an application at the board for compensation if this were to happen, but they can't get their place back. Over the last couple of years, there's been so much in the media about renovictions, they're being called, renovation evictions. And it is difficult for the tenant, and it's very expensive for the tenant, because to move out from a place you've lived at for perhaps 6-7 years, you're going to pay a lot higher rent. There are extensive remedies against the landlord if the landlord is found to have given bad faith notice. But in truth, even the most expensive fines and awards from the LTB can quickly be recovered by the higher rent the landlord will get. A bit of history before we go into the new bylaw. The Residential Tenancies Act used to be called the Tenant Protection Act. It came into force in 1998. And they had these protections to return at the same rent when the work's done. That's existed since 98, and it's existing today in the current act. But COVID changed everything. Rent inflation, which far outpaced general inflation, made things very attractive for a landlord to try to turn over tenants. The post-World War II rental stock is aging, so more work needs to be done. And of course, in Ontario, hundreds of thousands of mom-and-pop landlords have seen rental properties as a way to wealth creation and retirement. Sometimes the only way to wealth creation and retirement. In 2017, a bill was introduced by the government that resulted in some changes to the RTA, but they weren't extensive changes. Bill 124 changed the Residential Tenancies Act in that the board could now make orders of significant compensation if the board determined that the landlord was required to provide the tenant with the right to reoccupy, but failed to do so. Bill 184 came along in years 2000 and 2021. It was implemented over time, and there were a lot of changes that dealt with the N12s, which were for landlord and purchaser use, and the N13s for extensive renovation evictions, also for evictions for demolition. There was a new requirement that if the landlord had to file an application at the board to get the eviction, that an affidavit had to be filed at the time the L2 application was filed with the board. Changes in Bill 184 required compensation for all types of complexes, where before there were some types of residential complexes where no compensation was required. An amazing part of Bill 184 was the extraordinary increases in potential provincial offences fines for landlords who went to the board and submitted false or misleading documents. That would have been a declaration from their son or from themselves, saying that they wanted to move in. Now, that had nothing to do with the N13 for renovation. Tenants were given 2 years, up from 1 year, to file an application based on bad faith if it was an N13 renovation eviction. And that made a lot of sense because sometimes it took 8 months for the work to get done. So giving the tenant only 1 year cut it sort of tight. And then there was the increase in compensation to tenants on a T5 application. So a lot of changes and protections in Bill 184 in terms of protections for tenants where they were being served an N13 notice of termination where the landlord said they needed to renovate. In 2023, something remarkable happened. Bill 97 was introduced, and Schedule 7 of Bill 97 introduced many amendments that are similar to the City of Toronto amendments. When an N13 for extensive renovation was served, the landlord has to give the tenant, along with the N13, a report prepared by a person with the prescribed qualifications, so an engineer, an architect, stating that the repairs and renovations were so extensive that they required the tenant to move out. And if they didn't do that, the notice was void. And of course, to evict at the Landlord-Tenant Board, if it went to that phase, the landlord would have to have that documentation. The Act was amended, or was supposed to be amended by Bill 97, to require the board to consider that report in determining whether or not to evict the tenant, again, if it went to the hearing phase under the RTA. Sections 53 and 57 were amended so that if the tenant gave notice that they wished to return, the landlord had to give them specific notice regarding the unit's readiness for occupation. And once the unit was ready, they had to give them at least 60 days to exercise that right. Additional changes from Schedule 7 of Bill 97 deemed it to be bad faith if the landlord didn't advise the tenant of work completion or allow them to move back in. Provincial offences fines that a landlord could have faced following an LTB hearing if there was a provincial offences prosecution increased dramatically from $50,000 to $100,000 in the case of a landlord who's an individual, and from $250,000 to $500,000 in cases where the landlord was a corporation. A lot of provisions never were solidified. They were vague and waiting for regulations to be published. For instance, the regulations about who a qualified person might be to give the opinion. But we never got those regulations, and we never got passage of the Act because the minister at the time, Steve Clark, left the government under somewhat of a cloud, and the bill died with it. And perhaps if it had been enacted, if there hadn't been a new parliament, municipalities today wouldn't be thinking of introducing their own bylaws because these changes that were supposed to be introduced by the government were quite significant. So in November of 2024, the City of Toronto and the councillors and the mayor had heard enough, and they've received enough complaints from tenants saying they were getting evicted by bad faith renovation applications, that they weren't given the right to move back in. And of course, after hearings and committee meetings and council meetings, the bylaw was passed and comes into effect in just a few weeks now. It's quite a draconian, excessive, and cumbersome bylaw. I don't necessarily disagree with Bill 97 and what the government was trying to introduce, but this bylaw is confusing, it conflicts with the RTA, it's unworkable, it's too complicated for small landlords who don't have the sophistication, it's expensive, the timing issues may not jibe with the RTA. First of all, there's a requirement to submit a rental renovation license application within 7 days of serving the N13 notice, providing all sorts of details to the city, including, of course, the building permits, that report by the qualified person who must be licensed as an architect or an engineer. Licenses by the city will not be issued until the landlord has jumped through all these hoops, and licenses can be refused or subsequently revoked. So it's not enough to get a building permit. You have to take that and other information to the city to get your rental renovation license. You have to pay $700, and there's a requirement to provide the tenant with an accommodation or compensation plan for those who choose to return to their units or those who choose to move out. There's a requirement to pay moving expenses based on the size of the unit, as well as rent gap monies, and those amounts would be based on the amount between their existing rent, which is on hold during the renovation period, and some CMHC market rent data. So the tenant would not be out of pocket. Not entirely unfair, actually perhaps not unfair at all. There's a requirement to provide tenants with prescribed severance compensation where the tenant chooses not to return to the unit after the renovation work is done. And remember that this is money they'd have to give to the tenant in addition to the compensation that the RTA already orders. So in Toronto, as a tenant, I'm getting compensated twice, where in North Bay, I'm not. There's a requirement to post a tenant information notice on the door of each affected unit within 5 calendar days of issuing the N13 notice. You have to keep it there until the city issues or refuses the license. And after posting it, you've got to submit a photograph of that information notice to the city by email within 14 days of posting. Once the city receives the photograph, the 14-day notification period begins, and that gives the tenants time to review the notice and seek their rights and seek support before the city can issue a license. Once that period is passed, the landlord must submit a declaration form signed by both the tenant and the landlord indicating whether the tenant intends to return after the renovation. Where the tenant's chosen to return, the landlord has to submit the tenant accommodation plan or tenant compensation plan to the city, and both plans have to include info on the payment of the moving expenses and gap rent expenses. If the tenant chooses not to return, there are lump sum payments that they have to provide to the tenant, again in addition to the monies that are ordered under the RTA. The city reviews all these submitted documents to ensure the plan is being implemented, proof of compensation, the information plan, the information from the qualified contractor, etc. Once the license is issued by the city, the landlord has the obligation, of course, to implement the plan. The landlord must notify the tenant when the unit is ready for reoccupancy, and once back in, of course, the tenant moves back in at the same rent. Enforcement of the new bylaw begins on July 31st, but only applies to N13 notices issued on or after that date. In addition to fines under the RTA, which I told you about, quite substantial, fines that the city can impose are up to $1,000 for failure to submit the license application within 7 days of serving the N13, but up to $10,000 per day for any continuing offenses that are taking place, and up to $100,000 for evicting tenants without completing renovations or failing to follow the approved plan and allowing them to move back in. There are all sorts of timing requirements in each of the two systems, the bylaw and the RTA, and the problem is they don't mesh. And they rely on things working perfectly with your contractor getting back to you and giving you dates that are going to mesh with the city bylaw, and having the person who gives you the opinion give you that information in the proper time. If you get a license and you make certain guarantees in the application and in the compensation and accommodation plan, and then your contractor can't do the work then, or the contractor's slow in another job, what happens in terms of fines or penalties or the tenant's understanding of when they might be able to move back in? There could be situations where a conflict in timing prevents the LTB application from moving forward. In other words, you thought you were doing everything right, but the timing of getting the license didn't work out, and you either have a license that's expired because of time, or you have a hearing before the license is issued. The RTA and the city bylaw have some provisions that overlap. Why should certain tenants in certain cities get paid double? Why should fines be levied at both the provincial and municipal level? There's some provisions required by both, but with slightly different specifics and timing details. What happens if a landlord files the L2 application at the board and he has a permit but without a city license? He's waiting for the city license, and it's time for the application to be heard. The RTA requires a landlord to have obtained all necessary permits or other authority that may be required to carry out the activity on which the N13 notice is based. So they might serve the notice, file the application, provide the documents to the city, be waiting for a license to be issued, but not have the license. The city might be requiring the landlord to provide additional information. The landlord may have to move his dates because of the contractor. All of a sudden, he ends up with a hearing at the LTB, but he doesn't have the permit because he's dealing with the complexities of the City of Toronto bylaw. So the application's dismissed. What I think will happen is most small landlords will simply abstain from the renovation process. It's too costly, it's too complex, and they're just not going to understand how to make all this come together. Most small landlords are making sophisticated investments, but they're very unsophisticated operators. This is going to just be far over their heads and their abilities. It's likely that it's the older homes and basements offered by these small landlords, these mom and pop landlords, that are most in need of renovation, and yet they'll just say, I'll forget about it, this is too much. I think what will also happen is there'll be all sorts of deals made where a landlord pays a tenant to move out without using the N13. There'll simply be an agreement to move out, but it will require a large sum, because when a tenant moves out, it ain't cheap, particularly considering the increased rent they would have to pay. I also think, and I think this will happen a lot, that landlords are going to be doing necessary work by doing small projects, one at a time, and finding ways to accommodate a tenant's inconvenience. Maybe it means providing short hotel stays. Maybe it means providing some sort of movement within a building or in a house to temporary areas. But I think that they will try to do that, but just do small projects that don't take much time. I'm afraid that some landlords will just get building permits without advising the city there are tenants in the property. If they do that, of course, they could start doing the renovation. And if the tenant didn't know any better, the tenant may move out after getting the N13. But if it had to go to a hearing, the Landlord-Tenant Board wouldn't evict based on the N13 notice because the landlord doesn't have the renovation license. It's very complex and too complex for most small landlords. I think they should seek legal advice if they're looking for more information. And I hope that all landlords will take a look at landlordtraining.ca to find out what your rights and obligations are under the Residential Tenancies Act.